Welcome to the first lecture on the Law in Modern Society for Journalism and the Law, the online course for Temple University. So the basis of U.S. law is, really the single significant means by which society is ordered, and the rights and obligation of its members are defined. And the U.S. legal system is built on what's called case law. For the most part, and that's the written opinions that explain the various courts' rulings on legal issues and disputes. Now, there are some characteristics of U.S. law, and to a certain extent this exists in other countries as well, but the U.S. law has about 15,000 new federal, state, and local statutes that are enacted each year. And there are more than 50,000 judicial opinions that are published each year. And that adds to almost 3 million that are already in existence. And so that all of these statutes or laws and judicial opinions change the law in some way. So there's an interplay between the desire for flexibility and progress and the need to maintain stability and certainty. So that if you look at the Supreme Court, there is what is called the liberal wing, what's called the conservative wing, and some moderates on occasion. And so in this tension between the two sides, the liberal side wants more flexibility, progress, that there should be a living constitution, while the conservative bloc in the Supreme Court says the founders knew what they intended for this document and this rule of law to mean. And so therefore you adapt that to a certain situation, but you stay with what the founders' intention was. Social order depends on stability and the notion that people should be dealt with in the same fashion. So essentially it's, there but for the least of us go I, so that everyone has the right to an attorney. Everyone has the same rights to a fair trial. Everyone is seen as the same under the law. But the law also has to be capable of change to satisfy new aspirations and expectations. A great example of that is the U.S. Constitution itself, where it did not deal with the issue of slavery, and so it was amended with the 13th, 14th, and 15th Amendments to deal with the issue of slavery. U.S. law comes from a variety of sources. So the U.S. Constitution allocates powers between the state and the national governments. Each state's constitution establishes the framework for that state's government. And a fundamental part of these state and federal constitutions is the separation of powers between the legislative, judicial, and executive branches of government. And although lawmaking rests primarily with the legislative branch, all three branches exercise some form of lawmaking power. When we come to the central focus of this class, it largely rests on judicial decisions. Okay? When judges write their opinions, they look for some kind of authority to support their holdings. So occasionally they cite secondary authority such as encyclopedias or law journal articles or some social science research, but these are really not as persuasive as what's called the primary authority, such as laws, constitutional provisions, or other opinions, which are essentially precedents. So that the U.S. Supreme Court, all courts establish precedents, but the U.S. Supreme Court will rule on a case and it becomes the supreme law of the land as a precedent. Okay? There's some good precedents like the Brown v. Board of Education, which established a decision that all people should be able to have the same type of education. It actually set aside a previous Supreme Court decision which said that there should be separate but equal educational advantages for blacks and whites. The primary authority in U.S. law is the U.S. Constitution. Okay, so the constitutional law is the most important, or at least the most influential, source of law. The U.S. Constitution is the supreme law of the land. No law that conflicts with it can be valid. This is known as the Supremacy Clause, which is Article 6, Section 2 of the U.S. Constitution. Now, when it comes to state and local authority, each state, as I said earlier, has a constitution. Municipalities will have a charter in most cases, and these constitutions provide a written plan for organizing, establishing, and operating how government will function. They outline the powers and responsibilities, and they also limit the powers of the government by guaranteeing certain basic rights to the people. Now, when it comes to judicial review, this is something that happened very shortly after the Constitution was established. The Constitution really didn't say a whole lot about how the judiciary should be organized. It established a Supreme Court, didn't say how long the justices would serve, how many there needed to be, and in a case called Marbury v. Madison, the Supreme Court said that one of its powers should be to review the laws that had been made by the U.S. legislature, by the U.S. Congress. So that in judicial review, the Constitution, and both at the federal level and at the local level, are not always clear in their meanings. The language can often be and must often be interpreted. So the highest court in each jurisdiction is the final authority on that jurisdiction's constitution under the doctrine of judicial review. It's the principle that courts have the authority to review and to declare unconstitutional the actions of other branches of government. Now, the U.S. Supreme Court is the final interpreter of all laws, okay? So that in Pennsylvania, the Pennsylvania Supreme Court has a say in interpreting that state's constitution, but it can be appealed to the U.S. Supreme Court, and the U.S. Supreme Court has the last word on how the U.S. Constitution can be interpreted. And as I said, the principle of judicial review was established in 1803 with Marbury v. Madison, which is a rather interesting case. It happened that President John Adams had appointed a number of cronies, shall we say, to various posts just before Thomas Jefferson took over as president and James Madison, who was in the Jefferson administration, said, no, these people can't have their jobs. And Marbury sued Madison, and the Supreme Court basically found for Marbury, but they also said that we, the members of the Supreme Court, have the ability to look over the actions of, in this case, the executive branch, but also the legislative branch, the policy of judicial review. Statutory law is essentially, the laws that are created by most legislative bodies, Congress, state legislatures, ordinances adopted by city and county governments, and all of these are recorded in a systematic way, and they're arranged by subject, they're indexed, they're printed in codes. And the courts have the authority to interpret the meaning of the statutes and make the proper application. Some of these are important laws, some are not so important. Now, one thing that you'll run into from time to time is what's called common law. And this is what has been determined in the past 10 centuries or past 1,000 years in terms of decisions that were handed down by both English and American courts before the establishment of the notion of judicial review or codification of laws. It was the way that things were done. So the principle that courts are bound by the previous rulings or by the decisions of a higher court. Okay? And this reliance on precedent is known as the principle of stare decisis, which basically means let the decision stand. Okay? Now, the U.S. Supreme Court is not one that generally sets aside a precedent, particularly those that are established by the U.S. Supreme Court. Essentially what it is they say, well, we don't want to diss the previous members of the U.S. Supreme Court because we know that when we're no longer around that we don't necessarily want the next members of the U.S. Supreme Court to diss our decisions. Now, some have been set aside, like Plessy v. Ferguson, which was set aside by Brown v. Board of Education. But there are also some precedents that are still on the books, which are pretty awful. One was the U.S. Supreme Court decision during World War II, which allowed for Japanese to be put into essentially labor camps. That's still the law of the land, even though I don't think that it will be called out to be applied anytime soon. So here are some judicial approaches. So you apply the precedent directly, okay, to say, yes, we agree with the previous decision, full stop, okay? You modify a precedent to fit new facts. You'll see this a lot, okay? You'll establish a new precedent by distinguishing the new case from a previous cases, and then you'll overrule a previous precedent as no longer appropriate. And another option is to ignore a precedent which if you are not on the U.S. Supreme Court, you do so at your own risk at a lower court. Now, administrative law is something that essentially occurs with a variety of agencies, okay? And we'll look at some of these agencies later. The Federal Communications Commission, and you may hear one of my rants about the Federal Communications Commission. It is an independent agency which actually has the ability to be the judiciary, the legislature, and involves itself in executive rulings. So it's all three in one. There are checks and balances over the FCC, but not as many as I would like to see. There's also international law, which deals with the relationships between independent nations, and they're based on formal and informal treaties, agreements, and conventions. So Article 2 of the Constitution gives the President a great deal of unilateral authority to conduct American relations with other countries. So foreign relations is really in the purview of the executive branch of government. Okay? Article 1 of the Constitution grants the Congress the authority to approve these treaties, to declare war, and to fund transnational initiatives. So the President can say, we want to have a new agreement with Britain, for example. And he can propose that. It's then sent to Congress to be approved. The President can also make the case for declaring war against the Taliban in Afghanistan, but it's the Congress that actually votes to declare that war. There's something which is called the law of equity, and these are based on equity rather than law, and it essentially requires the parties to do something that they don't want to do, okay, or prevent them from doing something that they want to do. Okay? Some of these are cease and desist orders, restraining orders, writ of habeas corpus, which essentially says you got to bring somebody to the court. You probably heard about restraining orders that movie stars may have against photographers. So these are things to say, okay, we, the court, say to you that you cannot take a photograph within 100 yards of this movie star, even though you want to. Okay? So the law of equity. Now, here's something, most of you, I'm sure all of you have watched Law and Order or various crime shows, and so you have some sense of what goes on in a courtroom. But it's important to keep in mind that there are civil courts and there are criminal courts. Most of what we're going to be talking about in this class, they have to do with civil courts. So a libel case will go generally to a civil court, although there is criminal libel, but that's generally not what's used. Okay, and what happens here in a civil court is called a tort. It's derived from the Latin word tortuous, which means wrong, and a body of law that permits an injured person to recover compensation from the injuring party. So in a libel case, for example, you have published a story about me which is false and has caused harm to my reputation. So I have a civil tort to recover money from you because you defamed me, you libeled me in your newspaper, television station, online publication, whatever. Okay. Another one is when one person injures another, either intentionally or by negligent, a court may award money damages to the injured party. Also can be a libel case, but also could be a case where I was injured when you hit my car. And there wasn't any criminal act, but you as a result, you hurt my neck and I can't walk well anymore. Okay, and then there's a contract which is based on an oral or signed agreement. Okay, these are all civil cases rather than criminal cases, and a civil case has some distinctions from a criminal trial. In a civil trial, you have a lawyer for the plaintiff or the one bringing the lawsuit, and then you have a defense lawyer, okay, who represents the person who's being charged in a civil matter. Okay, there may be a jury. A jury can decide for someone to get money based on a majority decision. It's not a unanimous decision, as opposed to a criminal trial where there's a prosecutor that represents the state against me because I've committed a crime. There is, I will have a defense lawyer. There is also a jury who must find beyond a reasonable doubt and in a unanimous verdict. Okay, it's not beyond a reasonable doubt in a civil trial. It is not a unanimous decision in a civil trial. Okay, so these are just some things in terms of how the law functions in modern society, the background of how we got here, and some idea of how we will move forward in terms of this overall context in the class. So we'll see you online. Thanks very much.